The first of two class action lawsuits against Canada's major junior hockey leagues has taken another step closer to reality. Lawyers argue players are employees and they deserve to be paid at least minimum wage. In the meantime, the BC government has just exempted the province's 6 Western Hockey League teams from the need to pay minimum wage, including the Vancouver Giants and Victoria Royals. But first, we'd like to hear from you. Do you think junior athletes are employees and should be paid at least minimum wage? If you played junior sports, how did you make ends meet? Call us toll free across the province. The number is 1-800-825-5950. In Metro Vancouver, we're at 604-669-3733. From your cell phone at star or pound 690. Tweet us at BC Almanac or email us almanac@cbc.ca. In just a few minutes, we'll be joined by the lawyer leading the effort of filing these class action lawsuits. But first, for an academic's thoughts on this case, I spoke to Ken Thornycroft, a professor of law and employment relations at the University of Victoria's Gustafson School of Business.
Thanks for having me.
So what do you think of the BC government's decision to exempt Western Hockey League teams from paying their players at least minimum wage?
Well, the effect of the exemption, as you point out, is to eliminate the requirement for the teams to pay minimum wage and all other provisions of the Employment Standards Act. I think it's important to note, though, that the decision presupposes, in some sense, that the players are actually employees. If, in fact, the players are not employees, the exemption is sort of a moot point. I think, in my mind, what might have been driving this decision more than anything else was a desire to avoid potentially years of litigation over the question of whether or not these players are or are not employees. If they are employees, then the exemption is essentially taking away vested rights that the players would otherwise have under the Act. If the players are not employees, then the exemption is really just confirming the status quo.
So what determines whether a player is an employee and should be paid minimum wage?
Well, this is where it gets very, very difficult. If you look at the definition of employee in the Employment Standards Act itself, it's not particularly helpful. It talks about a person receiving wages for work performed. It talks about work normally performed by an employee. It talks about people being trained for an employer's business. So it's not particularly helpful. You can look to common law provisions and their test for whether somebody is an employee is, what were the intentions of the parties when they entered into a contract, who is providing the tools and equipment to do the work, is the person an independent contractor sort of in business for themselves. So it's an area that is a little bit gray. I think one of the things, though, is are these players working, or are they essentially student athletes who are engaged in playing hockey as other athletes are engaged in other sports with a view to sort of developing their future potential maybe for a professional career, or just because they simply enjoy the game and it's sort of a supplementary part of their existence as students. And I suppose that might be the fundamental question if this case ever were to be litigated.
Here in Vancouver, the Giants have quite a large profile. They charge ticket prices $19.50 to $40 per game. If you want to get a season's ticket, that ranges from $576 to $1,152. So shouldn't they be able to pay their players at least minimum wage?
I don't know. I'm not privy to the financial records of the teams. It's possible that some teams would be able to pay. It's possible that other teams would be challenged by that. But insofar as the law is concerned, whether or not the sort of nominal employer has the ability to pay is not really the question. I liken this case in some sense to college athletes. So you look at a college athlete who generally are a little bit older than the players who would be in the WHL, but they receive scholarships. In the United States, these scholarships have very significant value. If you're at a private university, the value of that scholarship is probably in the order of nearly $100,000 US per year at elite private schools. And the players are playing a sport, whether it's basketball or football or some other Division I sport, and the teams obviously charge fees for people to come to the game for tickets. Many of these schools have very, very significant television revenue. They often have their own broadcast networks. You look at the Final Four in the basketball tournament, very, very large TV ratings, millions and millions of dollars are changing hands, and yet in the United States, college athletes have been ruled not to be employees. They're athletes. And so the question then becomes, are these players more like sort of university athletes that are receiving some benefits in exchange for, playing their sport, or are they truly employees and it's an employment relationship and they should be paid as such?
Ken, thank you so much. Good to talk with you today.
Thank you very kindly.
That's Ken Thornycroft. He's a professor of law and employment relations at the University of Victoria's Gustafson School of Business. Do you think junior athletes are employees and should be paid at least the minimum wage? If you played junior sports, how did you make ends meet? I'll give you the numbers once again to call. 1-800-825-5950 in Metro Vancouver, where it's 604-669-3733. From your cell phone, star or pound 690. Send us a tweet if you like, at BC Almanac. Joining us now is the lawyer who is putting together this class action lawsuit, Ted Charney. He's a class action lawyer and a senior partner of Charney Lawyers in Toronto. Hello, good afternoon.
Hello, Gloria.
So what do you think of BC granting this exemption for Western Hockey League teams?
It's unfortunate. I agree with Professor Thornycroft that they saw the writing on the wall in terms of when this case gets to court, it's likely that the judge who hears all the evidence will decide that major junior hockey players are employees. That's what the real motivation was behind the commissioner of the Western Hockey League lobbying the government to exempt the players. There's no other reason to exempt them unless the league is afraid that they're going to be found to be employees in court. Otherwise, they should just have litigated the case in court. And if they're right that the players are not employees, then they'll win in court, and that'll be the end of it. But instead of having this case litigated the way issues are normally litigated in this country, they went around the litigation and approached the government and lobbied them directly. I've seen the Freedom of Information documents, and I can tell you that the main reason why the league thought that the players should be exempted was because of the so-called financial implications for the operation of the teams in British Columbia if we were to succeed in court and get a finding that they're employees. The entire lobbying effort was predicated on how all of the teams would be out of business if the class action were to succeed.
Ted, what sparked your efforts to put together this class action lawsuit in the first place?
We were approached by some of the former players, and I knew nothing about major junior hockey when we were approached. Our reputation is for doing class actions. We don't have any special expertise in hockey. But when these players told me about how much money they made playing hockey for the 4 years that they were in the league, I was just shocked. Back in 2013-14, before we started this case, the players were making $50 a week in the OHL, $35 a week in what we call the Q, the Quebec Major Junior Hockey League, and around somewhere between $35 and $55 a week in the teams in the Western Hockey League. And I just couldn't understand it. I looked into it a little more, and I found out that since the 1970s, the Standard Player Agreement has provided for wages at the same level, $50 a week. Sometimes it's called an allowance in the Standard Player Agreement. Other times it's actually called wages, depending on which league you look at. And they've been paying the same amount for the last 40 years. And, every 2 weeks the kids get a check. They call it a paycheck. Sometimes they get T4s, sometimes they get records of employment. For their overage year in the Quebec League, they're actually called employees, even though they play on the same lines as the kids that are 16, 17, and 18. They get drafted into the NHL at the age of 18, and they go back to the league and play another 2 years in the league, even though they're now professional hockey players in the NHL under contract. So I just found the whole thing to be very confusing. And then we tried to figure out how much the revenues are for these leagues, and whether they really are making any money, or are they an altruistic charity who is there just to develop these young men into fine young players, which is the position the leagues take, which I don't accept for 1 minute. I think they're in the business of making money, and that's why these players are entitled to be paid. So we figured out that the revenues that are being generated across the 3 leagues are in the range of about $200 million a year. And we figured out that through the NHL contracts and the Sportsnet contracts, there's revenue sharing that goes on where each team receives about $350,000 a year amongst the 60 teams in the 3 leagues. And, some teams make more money than others, but even the smallest teams have revenues in the range of $2 million a year. And what the teams will tell you and the commissioner will tell you is that they always break even or slightly lose money, but this is part of their business model. Even the hitmen probably just break even though they might have revenues of $50 million a year. It's just part of their business model. It's accounting. But the real question is why can't they pay minimum wage? It's $300,000 a year per team at the most. They've got a revenue sharing agreement which generates $350,000 a year per team. So if they're right, and that is some of the smaller teams can't afford it, well, some of the bigger teams could get less of that revenue sharing income. They probably wouldn't miss it at all. And it could go to some of the smaller teams. And there's other ways to do this. But, the reality is the way the league promotes their product, their marketing materials, tout the league as having 8,400,000 spectators who pay for tickets to attend the games, more than all of the other professional leagues in Canada, including the NHL, the CFL, and others, more than all of them all combined. That's the kind of business entity we're talking about here, who comes to the BC government and to the Labour Minister, whose riding happens to be the same riding as the Prince George Cougars are in, and tells them, please give us an exemption from paying minimum wage because we can't afford to pay it.
Okay, I'm going to get back to you in just a couple of minutes, Ted, but right now we have Ron Robison on the line now. We talk about this legal action being taken against all the junior hockey leagues. The BC government, as we pointed out, specifically made an exemption for the province's Western Hockey League teams. Ron Robison, the commissioner of the Western Hockey League, is on the line with us now. Good afternoon.
Good afternoon, Gloria.
I'll start by getting you to react to this email we just received from one of our listeners. Perry writes, junior hockey is a for-profit business. The players should receive minimum wage. So, Ron, why don't you think WHL teams should pay players minimum wage?
Well, first of all, you have to understand that the players registered in the Western Hockey League and in the Canadian Hockey League are registered Canadian amateur hockey players. We are the top level of the amateur hockey system. And what we're dealing with here is trying to preserve these opportunities for players to play at the top level of the amateur hockey system, to do so for other levels of junior hockey and the amateur hockey system, as well as the amateur sports system in Canada overall.
So how are the players compensated?
The players receive extensive benefits for playing in the league. The ownership throughout the Canadian Hockey League and the Western Hockey League invests heavily in the player experience. We provide all travel expenses, room and board, equipment and supplies, education, and a wide range of support services, including the top caliber of coaching, medical and professional support for the players. All of the necessary expenses they require to play at our level are taken care of. The stipend or the allowance that was referred to earlier is simply to cover any out-of-pocket expenses the player may have above and beyond the expenses that we provide.
Well, you heard Ted Charney, the lawyer, saying a few moments ago, more than 8 million people across this country pay for tickets to watch this. These leagues are run like businesses. Why shouldn't the players get a cut?
Well, the franchises and the financial position of the teams are certainly not being portrayed fairly at all. These franchises are not a profitable franchise. The industry is not profitable. The information that's been stated relative to the financial positions and operating budgets of the teams are completely inaccurate, and franchise values are grossly overstated. So I think it's a distorted message to send. The most important thing is that we're trying to preserve these opportunities for these young players to play in leagues like the Western Hockey League, continue to offer a world-class experience. We're fully committed to doing that, and the only way to preserve that really is to provide exemptions, and we really commend the government of BC for taking this step.
Now, if the teams aren't profitable, how come they're still going?
Well, they continue to go because ownership is committed to making sure that these opportunities are still available despite challenges from a standpoint of operating those teams on it. And this is something that other levels of hockey will indicate to you as well, and we are no exception. The operating expenses of operating a Western Hockey League team are very, very significant, particularly when you consider our travel, equipment today, and the operating costs of our teams up against the revenues that our teams receive. It's a very challenging business model for all of our WHL clubs.
Ron Robison, thank you very much for your time.
My pleasure. Thank you.
That's Ron Robison, Commissioner of the Western Hockey League. And back to Ted Charney now, a class action lawyer and senior partner of Charney Lawyers in Toronto. He's taken the lead in this class action lawsuit. Ted, what do you make of what you just heard?
Well, I've heard it before,
Uh-huh.
and I haven't heard anything new. But what I can tell you is this. We brought a court application in Calgary last week in the WHL class action, seeking the court to make an order requiring the Western Hockey League and all of its franchise teams to produce their financial statements and tax returns and their revenue sharing agreements with the NHL and with Sportsnet, Rogers Sportsnet, and so on. And the defendants opposed the motion. They're not prepared to produce any of their financial documentation, and we're waiting to hear back from the judge as to what his decision will be. So I think soon enough we may be able to understand whether or not the commissioner's statement about us having the numbers inaccurate will become much clearer in the very near future. It's unfortunate that the leagues have not been prepared to produce this information voluntarily, and in fact they opposed it last week. So what I have to say about this is that the numbers that I said to you earlier are right from the league's own marketing materials and from their own financial statements from the teams that we have. There's nothing about the numbers that I said that is wrong. There are 8 million to close to 9 million in some years spectators that pay tickets to see these games. And it is a going concern business. The other thing maybe I should suggest to you is that don't forget, the league is the feeder league for the NHL. It's the main source of talent for the National Hockey League. I don't think anyone's going to argue that the National Hockey League has plenty of revenues and plenty of assets, and I don't think the NHL is going to let the Western Hockey League teams get into trouble financially because they won't have their prospects coming through to the NHL. I mean, you have to understand that it's interconnected. The leagues in the major junior level are directly connected to the NHL. They're the farm teams. And also the franchises in the leagues need each other because they're providing a product that's called entertainment. The players are the entertainers. And you need teams to play against, and you need to have competitive play. Otherwise, no one's going to go to the games. So the prospects that these teams are not going to be around is just not realistic because you won't have a league without them, and the NHL won't have a farm system without them. So,
Ted, I appreciate that you've got more to add here, but I really want to bring in some of our listeners to the conversation. Al is on the line from Prince George. Al, welcome.
Hi there.
Your thoughts on whether the players should be paid at least minimum wage?
Well, my concerns are even greater than them being paid minimum wage, but it really, as a 5-year parent of a WHL player, and knowing how much money the boys have got over the years, and very often at times they are given a kangaroo type court fines where they lose their pay anyway to fines for various items taking place on a bus or on the ice surface. So the money is absolutely ridiculous, and it's not appropriate. But even more than that, my son, for example, had a serious concussion injury, and set out. It was 1 year from his last game played to the next game played. He had to sit out for a year. The medical attention which he was given was at our expense. For concussions, the options that were out there, for example, we pursued support from the same doctor that worked on Sidney Crosby. We had to pay out of pocket for that. The league wouldn't acknowledge that worked, even though Sidney Crosby acknowledges that it worked.
Now, Al, you just heard a few moments ago Ron Robison, the commissioner of the Western Hockey League, saying we take care of the medical needs of the players, we take care of the education along the way. What went through your mind?
We had to pay out of pocket because it wasn't accepted medical treatment for a concussion. The league, as I understand, supports medical concussion. From what we could get was stay at home and stay in the dark, and that doesn't cost them anything. And so I was very frustrated and very upset with the fact that these costs were not covered, and we covered out of pocket our own transportation to travel the 800 kilometers for assistance and to stay there.
So and we talk about some of these players do go on to play in the NHL. They get some fat contracts, but the majority do not. How is your son, and how is he doing now?
My son struggles with his injury today, and he is a changed young man, which is another irritation of mine, is they talk about paying for services for quality coaches. The coaches, or not all of them, there's some great coaches out there, but there are a large majority of old school coaches that call these boys young men so that they can abuse them at a higher level, that they can beat them down mentally and emotionally, and that happens on a regular basis. I love hockey. I loved watching my son play hockey, and unfortunately over the last few years of him being in the league, and seeing this stuff, it is very, very frustrating for me, and I have an awful feeling about the fact that my son was a hockey player. My son told me in his second year in the WHL that, Dad, I can work for any boss. I said, what are you talking about? He says, I can work for any boss, any job, anywhere. And I says, why? He says, there's no boss that can beat on me more than a hockey coach has beat on me. So they have trained me to be able to work for anyone. So that's coming from a boy who's very optimistic, very wanted to play at an extremely high level. He played at the U17 challenge, which is the top players in Canada play in that. And he had his dreams, and he was willing to work hard for them. And he, because of the system, he struggled, and I think in the end felt unsupported. His education suffered because of it. They talk about a great education package, and his education suffered for it. He is now taking in his second semester of upgrading so that he has a high school diploma, but his marks were not high enough to move on to a career choice that he was looking for. So
well, Al, I'm sorry to jump in here. We're going to have to wrap up the conversation, and you've made some incredible points. You painted a really sad story about how much your family has invested in the league and where your son's at now. I really appreciate you calling through. And Ted Charney, I imagine that you've heard a fair share of those types of stories.
Yes, we have.
So what happens now with your case, I mean?
Well, we have a certification hearing in Calgary for the week of February 6, 2017, and we have the same hearing in Toronto at the end of March 2017. And the parties now are gearing up for the certification hearings. If the case gets certified as a class action, then it'll proceed forward to trial, and we'll have a judge decide whether or not the players are in fact employees.
How do you think the case of American college football players might affect your case of Canadian junior hockey players?
Well, the defendants here in this case take the position that the players are amateur student athletes. And you heard the professor talk about NCAA athletes. But the difficulty here is you don't have the Vancouver Giants are not the University of Vancouver Giants. The kids are not going to university and then playing on one of the collegiate teams while they attend university. The players are playing for major sports enterprises who are in the business of earning profits from their revenues, and the players are not enrolled in the university while they're playing hockey, nor are the teams a university. So the analogy really doesn't work, but it's the best they've got because they have to come up with some way of characterizing the players to avoid the designation as employees. And so that's where they're headed, but we don't think it's analogous at all.
We certainly appreciate your time today, and we will be following your class action process with great interest. Thank you so much.
Thank you, Gloria.
That's Ted Charney. He's a class action lawyer and senior partner of Charney Lawyers in Toronto.